Hi everyone, welcome to the session on international arbitration. Today, we're going to look at urgent interim relief in international arbitration. Specifically, we look at the kinds of interim relief that parties typically require in international disputes, such as freezing orders and search and seizure orders, and the different contexts in which they may need these different types of orders. But before we look at each type of interim relief, let's first take a moment to understand their common characteristics. Remember, an interim measure includes any order needed to protect a party's rights before the final judgment, to make the final judgment or award effective. They typically consist of orders requiring the other party to preserve or not destroy evidence or assets, but they can take on any form really, whatever is needed in each case to maintain status quo and whatever is needed in the interests of justice to ensure that a final award is enforceable. These measures are usually applied for and sought on an urgent basis, as soon as one of the parties becomes aware that the other party is putting the assets or evidence relevant to the dispute at risk or is otherwise endangering the final award. In practice, this means that they are usually sought pre-commencement of the dispute as soon as the proceedings are contemplated. Applications for urgent interim relief are usually made without giving any warning to the other side. They are also usually sought for on an ex parte without notice basis, that is, without giving prior notice to the other side about the application and without the other side being present at the hearing where the order is given. This is for fairly obvious reasons. If you're concerned that the other side is going to hide or destroy evidence, for example, the last thing you want to do is give them warning that you are trying to obtain an order to stop them from doing this. With urgent interim applications, ensuring compliance is key to its success. Unfortunately, these characteristics of interim orders don't make them very easy to issue in the arbitration context. For one, the tribunal has to be constituted before it can issue the interim order, and it takes a fair bit of time for the parties to make their appointments and constitute the tribunal. 2. Tribunals are generally very reluctant to issue orders on an ex parte basis, as an opportunity of giving both parties the right to be heard is a cornerstone of procedural fairness, and tribunals are reluctant to deviate from this for fear that their eventual order or award won't be enforced. 3. Tribunals struggle to ensure compliance from rogue parties. Unlike courts, tribunals cannot enforce their own orders. 2. They cannot dangle the threat of contempt of court or civil or criminal penalties for non-compliance. 3. They also cannot bind third parties to their orders, which is often needed to ensure compliance. The different institutional rules have tried to come up with innovative solutions to enable arbitral tribunals to grant effective urgent interim relief. We look at these in more detail in the video lecture at Unit 5. For now, let's try to understand the different types of relief that parties typically require and how courts usually deal with them. A party might feel that there is a risk of their opponent hiding or dissipating its assets, thereby rendering any award in their favor useless. The best way of addressing this situation is to obtain a freezing injunction or a Mareva injunction to freeze or attach the assets of your opponent. Such an injunction will forbid the other party from moving, disposing, or otherwise diminishing the value of its assets up to a particular value, which is typically the value of the dispute. The scope of the freezing injunction can extend to assets located anywhere in the world, which is why it is sometimes called a worldwide freezing injunction. When issued by the courts, such injunctions will also bind third parties, namely banks, where the opponent might hold an account. Since such orders are quite draconian in nature, courts do not issue them lightly. Parties will generally need to show that they have a good arguable case, as well as that there is a serious threat of the assets being dissipated. Next, you may believe that your opponent possesses evidence which is relevant to the dispute, but that this evidence is likely to be destroyed, damaged, or lost. Sometimes, you may also believe that the relevant evidence may be with third parties, which your opponent may attempt to destroy. Here you want an order that protects the evidence. For example, you may seek an order requiring the evidence to be produced or delivered into safe custody, or an order requiring your opponent to identify its whereabouts and ensure its safekeeping. Sometimes you may not know the exact nature or location of this evidence. Here, you would usually use search and seizure orders like Anton Pillar and Norwich Pharmacal orders. Essentially, Anton Pillar orders are those used to secure entry into your opponent's premises, businesses, residences, or other places, to search for and seize evidence, including electronic evidence, when there is a risk that it may be destroyed if the action was to commence in the normal way. The applicant does not have to claim a proprietary interest in the material seized pursuant to this order. It is enough if the applicant can show that they need the material, usually documents, to prove its substantive claim. Like freezing orders, Anton Pillar orders are also usually sought for on an ex parte basis without giving the other side a chance to destroy the materials before the applicant can access them. And because they are also quite draconian, the applicant needs to show a strong prima facie case and clear evidence that the respondents have in their possession the relevant documents or things, and that there is a real possibility that they may destroy such material. A related order is the Norwich Pharmacal order. It is used to ensure that evidence in the hands of third parties, particularly banks, internet service providers, etc., will be preserved and turned over to the claimant for use in litigation. This remedy is often used in concert with Anton Pillar orders or Mareva injunctions, resulting in the ability of the court to gather critical information or to secure assets in the hands of defendants who are likely to thwart their obligations in litigation. Sometimes your dispute may be concerned with title in or the condition of property which is in the custody of your opponent, for example, a resort, a company, etc. If you are concerned that this property in question may be mismanaged during the pendency of the dispute, you may ask for the appointment of a receiver to manage the property to preserve its value in the meantime. These are the types of interim reliefs that claimants typically seek in an international dispute, but defendants too may sometimes need interim relief in an international arbitration. The most common interim measures defendants seek is security for costs. It is unfair to a respondent if, having successfully defended a claim, to be unable to recover its legal costs from the claimant. This potential unfairness can be dealt with by obtaining an order for security for costs. The order will usually require the opponent to pay money into court or provide a bond against which the winning party can subsequently enforce an order for costs. Also, unlike the rest of the interim orders we've discussed, security for costs is usually obtained only after proceedings are commenced, not before. This makes sense because you cannot ask a claimant to deposit money to recover costs which may never occur. A security for costs order is also a great tactical tool for defendants to use. These orders can make claimants think much harder about the merits of their case and often encourages parties to settle their disputes. These are just some of the examples of the kinds of interim relief parties usually seek. A court can order any variation of these orders to suit the particular facts of each case. As mentioned before, we can seek these orders before national courts or tribunals. Most national legislations provide for this concurrent jurisdiction with respect to interim orders. That's it for this session, folks. Thanks for watching and look forward to catching up with you all in Unit 5.